land of the Huron-Wendat, the Seneca, and most recently the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. In 2009, at a meeting of the G20 in Pittsburgh, Prime Minister Harper told journalists that what set Canada apart from most other developed economies was that Canada had no history of colonialism. The internet lit up, and almost every newspaper and magazine in Canada, and even some in the US, carried editorials or stories correcting the Prime Minister, reminding him that Canada was, in fact, a colony for over 300 years. Starting in the late 15th century, French and British expeditions explored, colonized, and fought over various parts of North America in what is present-day Canada. The colony of New France was established in 1534, and it was ceded to the United Kingdom in 1763 after the French defeat in the 7 Years' War. After 1763, Canada was a British colony, just like India, South Africa, Australia, Botswana, Kenya, Pakistan, and so on. The British province of Quebec was divided into Upper and Lower Canada in 1791, and then reunified 50 years later in 1841. In 1867, the province of Canada was joined with the two other British colonies of New Brunswick and Nova Scotia through confederation, forming the self-governing nation named Canada. And then the new dominion was expanded by incorporating other parts of so-called British North America, finishing with Newfoundland and Labrador in 1949. So European powers colonized the Americas, along with most other parts of the world, using a doctrine called terra nullius, which is a legal fiction that most land outside of Europe was nobody's land, terra nullius. So terra nullius is a term that's used to describe territory that belongs to nobody and therefore may be acquired merely by a state's occupation of it. So colonialism took different forms in different parts of the world. In some regions, the colonial powers focused on resource extraction. So they wanted rubber or gold or cotton, and they exported that back to Europe. And sometimes they wanted a colony primarily for its labor. And so they would enslave people locally, or they would capture people and move them across the ocean to work as slaves in other colonies. And sometimes what they mainly sought was land. And that form of colonialism is called settler colonialism. That's when people move in large numbers from the colonial power, from Europe, from Britain, from France, from Portugal, and they settle in the colony. And then, of course, they also engage in resource extraction. Canada's early economies were based on exporting lumber and beaver pelts and salt cod. But the more lasting form of colonialism in Canada was settlement, settling and assuming ownership over land that had been the territories of Indigenous people. So from the perspective of a history of colonialism, what is the difference today between India, Kenya, Ghana, and Pakistan on the one hand, and Canada, Australia, New Zealand, and the United States on the other hand? The first four colonies gained independence at some point in the middle of the 20th century. And when they gained independence, most of the colonial overlords left. So white people with British or French surnames moved back to England, or they quietly continued to live in the former colony, but they had no power. So at independence, generally the political parties that had led the struggle for independence took power and the white people left. But in former colonies like Canada, Australia, and New Zealand, independence was more or less peacefully granted through a slow process in which Britain retained a great deal of control over the quasi-independent colony, and the colony continued to be governed by the settlers. So the settlers never left. That's the difference in those colonial histories. And as a result, the Indigenous experience of colonialism in Canada is primarily one of land dispossession. In some cases, the Crown, that is the government of England, negotiated treaties in which Indigenous people ceded certain territories in exchange for guarantees that other territories would be recognized as theirs and would be protected from settler encroachment. But in other cases, there were no treaties, and Indigenous people never agreed to cede their land. So through the very colonial process of land accumulation and settlement, protected by first British and later Canadian troops and firearms, Indigenous people who once lived, hunted, buried their dead, worshipped, and traveled through 100% of the land of Turtle Island, those Indigenous people now exercise some minimal forms of sovereignty in 0.2% of the land area of Canada. So for many Indigenous people in Canada, colonialism doesn't seem to be a form of tutelage that ended 152 years ago. It seems to be ongoing in the sense that the settlers never left, and Indigenous people are still consigned to First Nations reserves where they still exercise very little self-governing authority. The residential school system was another institution through which Indigenous people experienced colonialism in Canada. So for roughly 100 years, between the late 19th century and the late 20th century, the government of Canada collaborated with various churches to operate a residential school system that forcibly removed Indigenous children from their parents and communities and placed them in boarding schools. So all told, about 150,000 children were sent to residential schools, starting from only 2 schools in operation when Canada was formed in 1867. A total of 130 residential schools existed over time, and the last residential school closed only 24 years ago in 1996. The explicit purpose of the residential schools was to destroy Aboriginal language and culture, to take the Indian out of the child, as Canada's founding father, Sir John A. Macdonald, famously said. So once you get back to school, once you're actually on campus at University of Toronto, you will probably walk by University of Toronto's John A. Macdonald House at 63 St. George Street any day of the week. So residential school students were not allowed to speak their own languages at school, and their cultures and heritages were debased, and children also suffered physical harm. Some schools had mortality rates of 35 to 60% due to malnutrition, abuse, and exposure to tuberculosis and other diseases. Many children were also victims of physical and sexual abuse. So through the residential school system, the government of Canada systematically violated human rights to bodily integrity, equality, privacy, education, culture, family, and even the human right to life. Canada's reckoning with the residential school system started in the late 1980s with prosecutions against former residential school staff in British Columbia and the Yukon in 1989 and 1990. So these were individual court cases. And then police investigations led to more prosecutions. By 1992, most churches had apologized for their role in the residential school system, but they also asserted shared responsibility with the federal government for the consequences of the residential schools. In 1996, the report of the Royal Commission on Aboriginal People included a detailed report on conditions of widespread neglect, governmental underfunding, health-related problems, and sexual, physical, and emotional abuse that had been endured by students over many years. And the Royal Commission called for a public inquiry into the residential school system. By October of 2002, more than 11,000 legal cases had been filed against the federal government and the churches. And as these lawsuits slowly made their way through the legal system, the Assembly of First Nations negotiated various agreements with the government, first for what it called an alternative dispute resolution system, and then for a settlement that was called the political agreement. But almost as soon as the political agreement was signed in August of 2005, the AFN, under the leadership of then Chief Phil Fontaine, launched a class action lawsuit against the federal government. So that was in August of 2005. In May of 2006, the government announced that all parties had approved what was called the Indian Residential Schools Settlement Agreement, which was an out-of-court settlement that represented a consensus that had been reached in discussions between the Government of Canada, legal counsel for former students, the churches, the Assembly of First Nations, and some other Indigenous organizations. And the settlement agreement is the largest, most complex class action settlement in Canadian history. And once it was approved by the courts, it came into effect in September of 2007. And the settlement agreement included a common experience payment, an independent assessment process, a Truth and Reconciliation Commission, commemoration, and funding for healing. So let's start with the common experience payment. The common experience payment was available to every one of the roughly 80,000 survivors of residential school who were still living in 2007. So former students were eligible to receive a payment of $10,000 plus $3,000 for each additional year beyond the first year that they spent in residential school. So the average individual payout for the common experience payment was $28,000. And in the end, the Government of Canada spent $1.6 billion, which it gave to 78,750 residential school students. The independent assessment process was a separate fund that survivors could apply for if they had not only attended residential school, but also been subjected to sexual or physical violence in the schools. And the IAP, the independent assessment process, received over 38,000 applications, and it dispersed over $3 billion. In general, I would say people were fairly critical of the IAP process. for assigning points for different types of abuse, as if the experience and impact of physical or sexual abuse could be objectively assessed by a neutral third party. So a survivor would get more points for sexual abuse than they did for physical abuse. If it happened only once, a person would get fewer points than if it happened repeatedly. Some sexual acts were actually assigned more points than others. And in order to get any points at all, survivors were compelled to tell stories about things that had happened to them as children that they had often never told anyone in their lives before. And then sometimes, after they told their stories, their claims were rejected. They were told that what had happened to them wasn't bad enough, or, as happened in the case of the survivors of St. Anne's Residential School in Fort Albany, Ontario, they weren't believed. And that was because the Canadian government suppressed the results of a police investigation that uncovered hundreds of cases of physical and sexual abuse and named over 74 potential perpetrators of abuse at St. Anne's Residential School. So the settlement agreement also allocated $20 million to commemoration and funding for a Truth and Reconciliation Commission. And the TRC was in operation from 2009 until 2015. And what the TRC did was travel throughout Canada, ultimately collecting testimony from approximately 6,000 residential school survivors. And the work of the TRC was primarily to uncover the truth, to set the record straight, and to allow people to tell their stories, and to have those stories be heard and believed and honored. So on the one hand, the TRC serves survivors of residential schools, many of whom have kept silent about what happened to them as children because they were ashamed, or because there was no space in Canada for that type of indictment of the residential school system, or because they feared that they wouldn't be believed. So the TRC offered a forum for people who wanted to unburden themselves, for whom talking might have been a step toward healing. The second purpose the TRC served, though, was in educating non-Indigenous Canadians about the residential school system. So up until very recently, until about 10 years ago, I would say, the dominant narrative in Canada regarding the residential schools was that the residential school system was well-intentioned, and that the system was put in place by good people who believed they were acting in the best interests of Indigenous children, but that in some cases things had gone wrong. Some children had been abused, some children may have died of disease, but these were mistakes and anomalies. These were aberrations from the norm. And in the wake of the TRC, that narrative is no longer possible. We now understand that the entire point of the residential school system was to destroy Indigenous languages and cultures. We know that abuse, violence, disease, malnutrition, and death were not occasional experiences in the schools. They were almost ubiquitous experiences in the schools. Canada's account of its own history has had to change as a result of the Truth and Reconciliation Commission. And that change acknowledges and accepts an Indigenous account of Canadian history that was ignored and rejected and suppressed for 150 years. The TRC concluded its work with the publication of a multi-volume report. So you were asked to read one chapter of the summary of that report for class today. And the Commission also released 94 calls to action. So these are 94 specific recommendations for federal, provincial, and municipal governments, for schools, for universities, for museums, churches, libraries, child welfare agencies, healthcare providers, and institutions, and so on and so forth. So the 94 calls to action sort of, I would say, pivot attention from truth, which was presumably the work of the Commission itself, to reconciliation, which is what comes next. And the 94 calls to action also broadened the scope of reconciliation from the residential school system to the legacy of the residential school system. So they broadened the scope from something that happened in the past to something with direct and persistent ongoing effects in the present day lives and life chances of Indigenous people in Canada. So let me step back a minute to put this idea of a legacy into some kind of perspective. The first sentence of the Canadian mandate for the Truth and Reconciliation Commission states, "There is an emerging and compelling desire to put the events of the past behind us so that we can work towards," let me see if I have this slide. No. "So that we can work towards a stronger and healthier future." In 2008, Prime Minister Harper stood on the floor of Parliament and he delivered an apology for the residential school system. And the next day, in response to the apology, one columnist wrote, "It is much to be hoped that Native Canadians accept the apology in the spirit in which it was offered and now move on, lest a grievance culture become so deep-rooted that they are unable to transcend it and self-identify with victim status forevermore." In other words, for the Canadian government, the apology and the TRC serve a political purpose. And that political purpose is to put the events of the past firmly in the past, to be able to move on, to reclaim Canada's moral authority without the past hanging over it. So the point of the apology and the settlement agreement, including compensation, the TRC, commemoration, is to seal off the past in which the Canadian government and churches and people committed cultural genocide against Indigenous people. It's about re-establishing the legitimacy of Canadian sovereignty. And not surprisingly, Indigenous people resist that logic. They do not see the apology and the TRC as an end. They see it instead as a beginning. So the legacy chapter, which describes and analyzes the legacy of the residential school system, the impact that attending residential schools continues to have among Indigenous people, that chapter establishes that what we're talking about when we talk about the residential schools is not the past. We are not talking about a terrible chapter in Canadian history as if that chapter has ended. So for Indigenous people, the impact of the residential schools is ongoing. And so what I'm highlighting here, what I'm trying to explain, is that there is a politics of reconciliation. For the government, reconciliation means moving on, putting the past behind us to reestablish Canada's moral authority and legitimacy as a state. And on the other hand, the legacy chapter is part of a political move to challenge that reading of reconciliation and to say, oh no, we are not going to be consigned to history. We will not allow Canada to move on as if the residential school system is done and dusted. Now that there is finally a consensus that the residential school system was, in fact, a gross violation of human rights, let's use that lens, that consensus, to shine a light on ongoing human rights violations, many of which flow directly from the residential school system. So, what is the legacy of the residential school system? This chapter lays it out in pretty extensive detail. The first is child welfare. Parents who spent their childhoods in residential schools often did not learn to live in families, and they didn't learn how to be parents themselves. Many suffer from addictions that can be traced to abuse that they suffered as children. Many Indigenous parents might have trouble caring for their children because they are poor, and that is a condition that can also be traced to residential schools. So by some estimates, the Canadian child welfare system is currently responsible for about 27,000 Indigenous children who have been removed from their homes. So there are currently more than 3 times as many Aboriginal children in the care of child welfare agencies as there were in the residential schools at the height of the system. So whereas 1 out of every 200 children in the general population is placed in the care of child welfare, 1 out of every 10 Indigenous children have been removed from their homes by child welfare agencies in Canada. The second ongoing impact is in the area of education. Most of the residential schools did a notoriously poor job of educating Indigenous children. In most schools, girls did all the cooking and cleaning, and the boys did the outside maintenance and farm labor. And only a small part of the day was spent in a classroom. And in an atmosphere of fear and abuse, where they weren't allowed to communicate in the languages they understood, many children left school having forgotten their home language and never really learning English well either. So they were functionally illiterate in 2 languages. And then, in turn, a poor education set them up for high levels of unemployment and underemployment in low-paying jobs. And then the report goes on to identify ongoing disparities in funding and quality of education for Indigenous children on reserves. The residential schools also devastated the languages and cultures of Indigenous people by interrupting the intergenerational transmission of knowledge that languages and cultures depend on. So the residential school system was actually quite successful at accomplishing exactly what it set out to do. Few Indigenous people in Canada speak their ancestral language, and most Indigenous languages in Canada are endangered because so few people speak them. The final report of the TRC also traces disparities in Indigenous health and healthcare, the overrepresentation of Indigenous people in prisons and the failures of the justice system, as well as violence against Indigenous women and girls to the residential schools. So it's a long list, and the calls to action that accompany the list of legacies are specific recommendations for reforms. So specific recommendations, the 94 calls to action, are specific recommendations that would put Canada on a path toward reconciliation. So since at least 2015, the discourse surrounding Canada's relationship with Indigenous people has been a discourse of reconciliation. So to put this in context, reconciliation marks a transition from earlier paradigms or frameworks that governed Canada's policies towards Indigenous people. So the first such framework, the first framework that sort of framed Canada's policies toward Indigenous people was assimilation. So assimilation was a nation-building project that focused attention on the problem of building a single national identity when your population speak different languages or practice different religions or have different customs and ancestral backgrounds. So this comes from a time and a place in which national identities were primarily built on cultural and linguistic identities. So, for example, we are all German because we speak German and we are descended from the Aryan race. And it also derives from the paradigm I described in the lecture on race. Remember, I pointed out that the difference that early travelers and settlers saw was not primarily one of race, the way we now understand race, but instead one of civilization. So the logic of assimilation was the logic of civilization. The mission of the nation was to civilize those people who are not yet civilized, to erase the differences that threatened the unity of the nation. So the point of the residential schools, or put differently, the residential schools, that policy, that public policy was developed in the context of thinking that the solution was assimilation. So the solution is assimilation. The specific policy that we're going to put in place is a residential school system. In many countries, though, assimilation is now widely regarded as an illegitimate strategy of nation building. The attempt to eradicate the language and culture of a people is now called cultural genocide. And so Canada turned from assimilation to multiculturalism. And multiculturalism was primarily driven by a concern over Quebec separatism. So it's not primarily driven by the Indigenous problem, but multiculturalism was then expanded to include Canada's policies toward immigrant populations and also its Indigenous populations. So Indigenous culture and symbolism has really entered mainstream portrayals of Canadian national identity in the last 10 or 15 years or so. Probably most forcefully at the Vancouver Winter Olympics in 2010, where you could honestly have been forgiven for making the assumption that Canada is, in fact, an Indigenous nation run by Indigenous people with a predominantly Indigenous culture. And then, of course, we've all seen images of Justin Trudeau wearing a feathered headdress. And Vancouver has named itself the City of Reconciliation, and it now uses a lot of Indigenous symbols and art in public spaces, at bus stops, at the airport, on manhole covers, literally in hundreds of public spaces, in order to foreground its Indigenous identity. And that type of reconciliation, you've probably heard, has also slid into the zone of appropriation, cultural appropriation. And that's when symbols or images associated with some particular culture are used by outsiders as fashion statements or as sports uniforms or mascots without any understanding of or reference to the origins and meanings of those symbols or images, and also without permission. So beyond culture, the framework of recognition also focuses attention on the rights that flow from treaties and from prior occupancy. So it's not just cultural recognition, but also legal recognition. So in the last 30 years, most of the victories that Indigenous people have secured in terms of gaining access to land or stopping extractive resource development on their land, most of those victories have come through the legal system. And these victims stem from the court's recognition of rights that derive from treaties and from prior occupancy. Not only that, but in 2007, the United Nations adopted something called the UN Declaration on the Rights of Indigenous People. And this is basically a statement of principles that states agree to adhere to or to aspire to with regard to Indigenous populations. So initially, Canada was one of only 4 countries that voted against UNDRIP, along with Australia, New Zealand, and the United States, all settler colonies with very bad records of human rights violations against Indigenous people. But in 2016, Canada reversed its position and declared its support for UNDRIP. So for Indigenous people, UNDRIP is therefore another source of rights to draw on. So for example, one of the principles that's enshrined in UNDRIP is something called free, prior, and informed consent. And this is a principle that is also enshrined in Section 35 of the Canadian Constitution, where it's called the duty to consult. So the duty to consult in Canada has generally been understood as a corporation's duty to consult with Indigenous people before, for example, building a pipeline that goes through their territory, or before sending oil tankers through waters that Indigenous people use for fishing. So what exactly is meant by the duty to consult, which is constitutionally enshrined, has been legally contested. So sometimes the duty to consult is translated narrowly, as in a corporation has a duty to let an Indigenous band know what their plan is and to get feedback, but that's it. And sometimes it has been translated more broadly, as in the corporation has a responsibility to actually get buy-in by a First Nation that is affected by a particular development project. So the duty to consult might be bolstered or made more robust by the principle of free, prior, and informed consent that's embedded in the Declaration, because consent is stronger language than merely the duty to consult. You know, it implies that you have to get consent from the First Nation. So one problem here is that the UN Declaration is not actually legally binding. It's an international declaration, which means that it is not binding on a country's domestic law, even if the country has signed on to it. But that doesn't mean that a lawyer acting on behalf of an Indigenous community might not invoke UNDRIP in court. So they might invoke free, prior, and informed consent in court. And if a judge were to accept that argument, then that argument would establish precedent. And then once free, prior, and informed consent is established through precedent, then it is part of domestic Canadian law, right? So there are ways in which the UN Declaration could be drawn down into domestic Canadian law and become part of legal precedent, and then it would have an impact on future legal decisions. At any rate, since at least 2015, when the final report of the TRC was released, the framework of reconciliation has really dominated Canada's public discourse regarding Indigenous people, and it has framed its policy making. And unlike assimilation and recognition, reconciliation underscores or foregrounds the broad range of injustices that have characterized the relationship between the Canadian state and Indigenous people. And it draws attention to the obligation to redress injustice and to chart a just future, or a more just future. And I would say that many non-Indigenous Canadians have really embraced the theme of reconciliation. The Liberal government of Justin Trudeau responded very quickly to the calls for action by launching a national inquiry into missing and murdered Indigenous women and girls. The Canada Council for the Arts sponsored a major initiative called Reconciliation to promote artistic collaborations between Indigenous and non-Indigenous Canadians. Indigenous and Northern Affairs Canada foregrounded reconciliation as a fundamental departmental priority. The Royal Winnipeg Ballet Company commissioned and performed a ballet on the topic of reconciliation. Following an officially designated year of reconciliation, Vancouver named itself the City of Reconciliation. And in 2017, the Canadian government identified reconciliation as one of the official themes of Canada's sesquicentennial celebrations. That is the 150-year celebrations of Canada. And since 2015, churches, public libraries, schools, museums, universities, and community centers across the country have sponsored countless talks, workshops, displays, and performances to raise awareness around reconciliation and to include regular, ordinary Canadian citizens in the project of reconciliation. In fact, reconciliation is so ubiquitous that a satirical website called Walking Eagle published this article about Prime Minister Trudeau's response to World Indigenous Peoples Day last summer. And as this satirical stab at reconciliation suggests, many Indigenous people are pretty skeptical about reconciliation. So a couple of years ago, for example, the Supreme Court decided that Ottawa has no duty to consult Indigenous people before passing legislation that might affect their treaty or land rights. So this was specifically a legal ruling against the Mikisew Cree First Nation in Alberta, which had argued that two omnibus budget bills introduced by the Conservative federal government in 2015 and 12 affected their constitutionally protected treaty rights because they amended regulatory protections for waterways and for the environment. So they amended those regulatory protections without consulting the Mikisew Cree and other First Nations across Canada, and the amendments to those regulations would affect water and land in First Nations territory. So they were arguing that Parliament, and not only private corporations, had a duty to consult First Nations when the decisions they were making would have an impact on First Nations. But they lost. They lost that legal case. And Indigenous people argue that losses like that offer evidence that the government is not serious about reconciliation. So I'm going to end this lecture here. There are, you have to read for today an article that I wrote called Reconciliation, 8 Reasons to Worry, that basically goes through some of the things that I've talked about in this lecture, and also identifies reasons, more reasons, that Indigenous people would have to be wary of the framework of reconciliation. Notwithstanding